This one is new and a little odd, but in some situations, the VA might apply your intent to file to the wrong claim, causing you to lose the effective date you were trying to preserve with the intent to file in the first place. This can happen if you have 2 or more disabilities at different stages of the claim or appeal process, and then file a supplemental claim for one of them. By doing that, it might then take the intent to file off the table when you didn't want it to. And we call different claims at different stages claim streams, by the way. But back to the intent to file thing. A little background might help. So originally, the VA regulations said that an intent to file could not be used on a supplemental claim at all. Then last summer, 2021, for whenever you're watching this, the United States Court of Appeals for the Federal Circuit tossed that part of the VA regs. So now you can use an intent to file with a supplemental claim. And that was a great decision. It was the right decision, and I'm glad the court fixed it. But as is often the case, the solution to a problem can also generate different problems. And in this case, it does. I think an example will help. So let's say you just received a decision that puts you at, 50% for PTSD. And you also have sleep apnea, which you believe is secondary to your PTSD, but you've never filed a claim for it, and you aren't ready to because you need to develop more evidence. But you still go ahead and file an intent to file to preserve your effective date for that sleep apnea claim. Next, let's say you file a supplemental claim on your PTSD a month after you filed that intent to file and within 1 year of the last PTSD decision. Then, several months later, when you receive the decision on the supplemental claim, you realize the VA linked that intent to file to the PTSD supplemental claim, and now you don't have it for your sleep apnea claim. Now, because that supplemental claim was within 1 year of the last decision, I think that's an error because the VA is obligated to give you the earliest effective date it can under the law, which would be much earlier than that intent to file. But that doesn't mean they won't try to take the intent to file off the table anyway. But let's say you filed that PTSD supplemental claim more than a year after the last PTSD decision. Now, in that case, which claim should the intent to file relate to? And you have to keep in mind that the VA doesn't know you're planning to file a sleep apnea claim because the intent to file form doesn't require you or even really offer a way for you to state which disability you want it to apply to. And that's not a bad thing. So why does the VA do this? The VA has to follow its regulations, which currently only allow 1 active intent to file form at any given time. And the VA's interim guidance following the court case I mentioned earlier says, and I'm paraphrasing here, if you file a supplemental claim within 1 year of an intent to file, the VA will associate that supplemental claim with the intent to file. So, on the more practical side, I don't yet know how to prevent this problem. The law in this area is unsettled, and I would be skeptical of anyone who's telling you that they've got a guaranteed way to fix this. But I will tell you what I'm doing with the veterans I'm working with. If there is an active intent to file, and then we file a supplemental claim for something different than what the intent to file is for, I will specifically say in the argument that the veteran does not want this supplemental claim to be associated with that intent to file. I will also immediately file a new intent to file right after the supplemental claim, just in case that argument doesn't work. I'm also trying very hard to keep claims grouped together, because if there are fewer claim streams, then there's less of a chance of this problem popping up. And that's a totally defensive strategy here. And my goal is to preserve effective dates as best I can for the veterans I'm working with. And I don't know if the arguments that I think are very compelling for why the VA should be pro-veteran and how it interprets these intent to file forms is going to hold up. And none of us will know until I or some other veterans advocate takes a case like this up to the Court of Appeals for Veterans Claims. And that can take a few years, even if it starts now. So we're going to be dealing with this situation for a while. I suppose the VA could also update the relevant regulations to deal with this. I'll keep watching for that. We'll see if it happens. The main point here is that VA disability law can be tricky. No single strategy is going to work for every claim, and you need to pay attention to how a supplemental claim might affect an intent to file that you've filed for something else. So I hope you found this video helpful. If you'd like me to help you with your VA disability claim, you can reach out to me through the links below. I'm Al Walsh, a veteran who likes to help other veterans. Thanks for watching.